This is Elektra Yao, immigrant. Letting Facebook log in. Thank you, everybody who has wished me well wishes for my most recent award. Very excited to be recognized in my profession for the work that we do. So, very excited about that. Today, I want to talk about something that comes up all the time during my consultations. So, I think that this is due to the fact that. Sometimes when people go have consultations for a specific visa type and they go to an attorney that's kind of a generalist, that attorney may or may not have all the information or understand all of the nuances of, for example, the artist visa. So, a question that I always get asked or that always comes up during my consultations is, do I need an award to qualify for the O1? And I think that that question comes up all the time because in the regulatory criteria, basically they state, okay, if you have an award, great, you qualify. If you don't have an award, then you have all this criteria that you need to satisfy. It's a minimum of 3. So a lot of the times clients will go to attorneys and attorneys will say, oh, you don't have an award, so you don't qualify for the O1, and completely discount the client and the client's achievements. My most recent review that's on Google, feel free to go on Google and read our newest review. Our client basically stated that she went to 3 other attorneys that said that she did not qualify. And with us, she was approved regular processing in 3 weeks, no RFE. So this just illustrates the importance of working with an attorney that really, really understands O1 visa, artist visa law, and the arts. Because again, she went to 4 attorneys, me included. 3 attorneys before me said that she did not qualify for the O1. Working with me, she got approved, no RFE, no premium processing in 3 weeks. This really is very, very important. It shows how critical it is to work with an attorney that is experienced. So again, like I said, do I need an award to qualify for the O1 visa? Now, the answer is no. You do not. Not at all. You do not need an award to qualify for the O1. You do not need an Oscar. You do not need any type of award to qualify for the O1. Even if it's a regional award, a national award, an international award, you do not need it. In fact, when I'm talking with my clients and when I'm advising my clients, I'm not telling them to focus on awards. I'm telling them to focus on diversifying the achievements within their career because that is what's going to help us win the O1, win the extension, and win the EB1A self-petition green card. So you should not be focusing on, do I need to get an award? How do I get an award? Because like I said, it's not necessary. I work with many clients. In fact, the majority of my clients do not have awards, and 99% of my clients are approved. So again, you do not need an award to qualify for the O1. Is it helpful? Is it something that helps your petition? Is it something that bolsters your professional profile? Is it something that speaks to your reputation and your leadership within the field? Absolutely. So, if you have to choose between diversifying your achievements and working a lot versus trying to garner an award, submitting yourself for an award, etc., and you don't have a lot of time, I would focus on diversifying my achievements. Of course, in a perfect world, you would do both. Work a lot and submit your work to get awards and to be recognized in your field. But for O1 purposes, right, for this very specific goal of securing the O1 visa, is it absolutely necessary? Is it a requirement? Is it a hard requirement to get an award for the O1? The answer is no. It is not a hard requirement. You do not need to do that. Now, with that being said, as I said afterwards, previously, you can have an award. Awards are great. I can use them in a lot of different ways in terms of evidence and in terms of crafting my legal arguments. It really helps me, again, cement your leadership within the field. And remember, leadership is one of the criteria that we need to prove, or that I typically argue. It cements your reputation of sustained distinguished merit, which is a part of the regulations. And overall, it's an achievement of you being recognized by a distinguished organization. So I can use it 3 different ways. So you can absolutely get that award, but it is not necessary. It is not dispositive to you getting the approval on your case. Now, if an award is not necessary, then what do you need to qualify for the O1? That is usually the second question. If I don't need an award, then what do I need? So I'll give you a brief rundown of the different criteria that is necessary to qualify for the O1. So there's 6 regulatory criteria. Now, I will preface this. I am discussing this in a way that is easy for a non-lawyer to understand. So if you're listening to me and you're going to the federal regulations or you're going to the USCIS and you're trying to compare what I say to what's on USCIS's website, you're going to find 2 different types of language. It's not going to look exactly the same. So I had this actually happen to me during a meeting with a client where they're like, well, the way you're describing it is not the way it's described on USCIS. Yes, exactly. It is not. It's not supposed to be described the way it is on USCIS because USCIS's website and the federal regulations are very confusing if you're not an attorney. So I'm explaining it to you in a way that I explain it to all my clients that get approved. So there's 6 regulatory criteria. You need a minimum of 3 to qualify. I typically argue 4. Sometimes I can argue 5, depending on the profession. So sometimes I can argue commercial success if you're a model, if you are a creative director, if you're an influencer. Those are the types of professions that will allow me to argue commercial success. But I typically argue 4. And the way I'm describing it is not the way it's described in the regulations. So the first criterion, the first thing you need are testimonial letters, expert letters, letters of recommendations from experts in your field that can confirm your expertise, right? So if you were a filmmaker, you need someone within the visual arts world or filmmaking world that can confirm exactly what we are trying to assert within the petition. Number 2, you're going to need press about you or the projects that you work on. This is extremely important because USCIS is gunning for that. And I believe that this is one of the criteria that you can control. This is something that you can work on throughout your OPT. You could work on while the petition is being developed. It's not something that is necessarily like a job, right? Where you go to an audition or you submit your portfolio and you kind of just don't know what's going to happen. No, with the way press works in 2022, you can absolutely control and curate this aspect of your career. Number 3, portfolio. Portfolio is the past component of your work. So if you're a filmmaker, let's just take that for an example. We are looking at your past work, your portfolio, your past work, your presentation of everything that you've done in the past. This is the films that you've done, the projects that you worked on, the artist talks that you've given, whatever it is that you've done, that goes into the portfolio. That's past work. And then future work, right? These are your future contracts. This is also known as a letter of intent, a job offer letter, an employment letter, a summary of the terms of the agreement. There are lots of different ways to call this, but let's just call it a contract because it's the easiest way for you to understand what I'm talking about. So the contract is really the future work. It's really you proving to USCIS that, hey, I know that I need to work, and this is my presentation of the work that I'm going to be doing in the future. Look at my dates, look at my role, look at my projects, etc. Those are the 4 things that you need to prove: press, portfolio, letters, and future work. I broke it down in a very, very simple way, but I find that if you look at it in those simple terms, then it allows you to really focus on what is critical for me, right? Which is your process as a creative person and the organization of all of this data so that USCIS can understand what we're talking about, or can understand your field of endeavor. So I want to give an example of something to illustrate what it means to talk to an officer about art when you are an expert in the arts and the officer is not. So if I turn around and I'm making all these faces, are you going to know what I'm saying? The answer is no. You're not going to know what I'm saying. You're not going to understand the gestures that I'm making. You're not going to understand my facial expressions. You might lose my cadence. You might lose my intonation, all because our perspectives are different. And I just want you to have that in mind when you're working on your artist visa, when you're working on your portfolio. The officer absolutely does not understand, in expert terms, which is what you are, what your profession is. Now, if you do not break it down for the officer, you are doing a disservice to yourself and you're doing a disservice to the officer. Our goal as attorneys when we're representing our clients is to make sure that even if it's the most complex case and complex artistic profession, that the officer understands it and approves it. And that exercise that we just did, this is just to illustrate that if you do not speak and explain things in a methodology that an USCIS officer will understand, that is the difference between getting the case approved and not approved. So this is not the time, the O1 visa, not the time to really speak in industry terms, right? And when we do use industry terms within our petitions, we really try to explicate it and explain it so that the officer is not lost. Because think back to when you were in school. Let's say you didn't understand a concept that the teacher was explaining. It kind of just went over your head, right? You kind of just ignored it because you weren't processing the data. It's the same thing with USCIS. Because they're reading so many petitions daily, and most O1 petitions or EB1A petitions are this big, right? Just to give you perspective, this is a hand sanitizer bottle. This is pretty big. A petition is about roughly more than half, right? That's a lot of data. That's a lot of technical data that they need to review. And then there's the merit-based data. This is the merit-based data is your artistry. It's your art. The technical applications, this will always be included in every petition. It's the immigration forms. That's the technical O1 artist visa application. Your merit-based data, your portfolio, your letters, that takes up a large part. And if you're going over their head because you're using terminology and you're describing your art in a way that they're not understanding and they're not engaging in, you're not going to get approved. You're going to get an RFE, a harsh RFE, where you're going to be required to re-argue the case all over again. So it's very, very critical that you do not focus on one aspect of the regulatory criteria, which is the awards. The awards is a very, very small part of the petition. And frankly, honestly, if you have won a major award, chances are you're prepping for an EB1A self-petition green card. You're usually not going to be prepping for an O1 because you will have exceeded the legal standard. You're overqualified for the O1, which is why every time I hear a client ask me or a potential client ask me, do I need an award? Another lawyer told me I have an award. I just do my best to explain to them that it is critical to work with an attorney that has experience with artists, that understand the arts and everything that goes within the industry, and that most importantly, understands the nuances and the complexities of the O1 artist visa. So just to recap, you do not need an award to qualify for the O1. I strongly encourage you to diversify your achievements, get special projects, artist talks, work for organizations, leadership within organizations. And that is what's going to be dispositive to you getting approved for your case, not an award. So I hope that this was helpful. Our next video, we will talk about high salary. And a lot of the times clients are like, well, I'm not going to be making a lot of money. It's just a nonprofit that's hiring me. Well, you don't need to make a prevailing wage like you need to for the H-1B. So I hope that this was helpful. I hope that you will focus on your achievements and not necessarily only awards. And I will see you tomorrow to further discuss high salary. Bye, everybody. Have a good day.